All right, we're live. Hang on. Okay, so can somebody just check on YouTube and let me know? All right, let me give you a link. Hang on. Sorry. There's the link that we're streaming to right now. Can somebody just give me a yay or a nay on audio coming out the other side on YouTube? I know the video is streaming, but it's always been the audio that's been the pain. Audio is fine. Good. And then would somebody just say something? Just say something. I probably won't hear it still. I don't have that part fixed. Just one of you on Discord, if you wouldn't mind saying something. And the question is, can I hear it and will it show up on YouTube? I see Jesse talking and I don't hear anything. Okay. Well, if we could limit ourselves just once again while I continue to debug this thing. Um, Wait, let me try something. Okay, can I get somebody else to say something? Anybody? Hey, yes, Jacob, I heard that. I hear that now. Now the question is, can someone jump over on YouTube and see whether we hear Jesse's audio on YouTube popping out? Got a yay or a nay on that? I mean, what this is going to buy us if I can get this fixed is, did not hear him on YouTube. Okay, let me just check one other thing. I don't know. That's progress, so at least I can hear you. But I think that, so yeah, are we still, Andreval, we're persuaded we did not hear. Okay, yeah, we can't hear you guys on YouTube. That's okay, though. At least I can hear you and maybe try to repeat it or something so it pops out on YouTube. But my audio is still good, it sounds like. Okay, that's good. Okay, good enough for now. All right, hey, everybody. David, what is that? That's creepy, Dave. What is it? I don't know the reference. Oh, wake me up. Wait, no, not When September Ends. That would be Green Day. Um, Evanescence. Misspelled badly, I think. Nice. Okay. That's awesome. Uh, okay. So, we're talking about intellectual property. That's where we decided we would start today. Do you remember this last week? I remember. Where's my. There we go. Sorry for the slow start, everybody. So I'm just trying to open my PowerPoint slides. There we go. Okay. All right. Hey, everybody. What's up? What do we got? 4 more weeks? I think it's 4 weeks. Tell me if that sounds right. We got the 29th today. We got this week. Then we got 1, 2, 3, 4.5. So 4 after today. Exactly 4 after today. All right. Just keep pounding, man. Just keep pounding. Okay. Where are we? By the way, I just want to point out this thing here that I grabbed. It's just creepy and weird. You see it right here on the? It disappears. Thanks for the tune for the Evanescence. I will give it a listen when I get a chance. Um, all right. It feels like the chat's really quiet. That's okay. Slow starting. Let me ask you this. I'm going to start with a survey. We'll get everybody moving with a survey. There's the survey question. I am at least a little bit interested in going to law school. So a yes means non-zero positive. A no means not in the least. Okay, not the least bit. I honestly don't expect this number on the yeses to be any higher than a couple. That would be traditional. I can tell you this, that if you start with a CS degree, this is not a hard pitch, but if you start with a CS degree and then you tack on a law degree, and if your, desire is to um, be an intellectual property attorney, you can kind of write your ticket uh, financially. Now, the other thing about it is, depending upon what kind of intellectual property attorney you become, like if you want to be a trial lawyer and deal with, patent litigation, copyright, trade secrets, that kind of stuff, you can make some serious bank. You can also endure some serious lifestyle pressures. Okay. Um, I will tell you that I had a solid look at law school um, as a potential destination for myself. Eventually decided against it, and then paradoxically, ironically, whatever, however you want to say it, wound up spending a lot of my career doing legal stuff, but coming at it more from the perspective of the expert witness, the testifying expert. Um, in every in every sort of legal case, there needs to be a testifying expert. So that's just in terms of the litigation side. Somebody has to be in a position to sort of enter technical opinions into the record as evidence. An attorney can't say, "Here's what I think this technology means," because they're not, they're an expert in the law. They may be an expert in the technology, but the system is set up so that they're an expert in the law. Somebody else has to come and be an expert in the technology. And that's something I've done a lot of over, the past about 20 years. I think the first time I ever did anything like that was about 19 years ago. 19 or 20, coming around. I think it was maybe '03, which would make it about 19 years. Um, so it's something that I've just wound up learning a lot about, just kind of almost really by accident. I never really set out to be an expert in, you know, sort of intellectual property litigation, um, or these sorts of topics, right? Uh, and when I say expert, I'm not using the legal term for that. I'm just talking about the notion of gaining expertise, in a certain topic, using it as kind of a layperson. So we got 4 people that are potentially interested. Uh, 5. Did I accidentally click on that? Yeah, I did accidentally click on that. If any of you want to, talk ever about that, I'm happy to talk it up, talk it down, whatever the case may be, but give you at least an honest sense of what life might look like as a person with a CS degree and a law degree. But I will tell you that it is, if you like that kind of work, it can be very, very, lucrative, can set you up very, very well. So what I wanted to try to do here today to start with was just talk broadly about intellectual property, and I'll get you over here, and then talk specifically about these kinds of intellectual property: patent, copyright, trademark, trade secrets, employment agreements, intellectual property rights, non-competes, non-disclosures. At your stage, you probably haven't heard a lot about most of these things. And the other thing too, let me be like really, really clear. I'm not an attorney. I don't even play one on television. Um, I'm giving you kind of my sense of things that I've learned. Uh, an actual attorney might say different things than I'm saying here. I'm not, you know, as somebody who's been a testifying expert, I've been around the block, but I'm not an expert in the law in that same sense, right? So I sometimes refer to intellectual property as the other IP, right? The best IP, the coolest IP would be Internet Protocol, right? That's the one you're mostly familiar with. But the idea behind intellectual property is, any property that you own is sort of, it's a legal monopoly, right? I own my car. I have a control on who gets to use my car, who gets to ride in my car, who gets to drive my car. And if you jump in my car and take off without my permission, we call that stealing my car, right? So intellectual property is just like physical property, where, instead of a legal monopoly on the physical property, this pen or, these AirPods, whatever we call them, you're actually grabbing yourself a legal monopoly on something intellectual, something a little more abstract, perhaps. Um, and that could take the form of, if I have a trademark, you can't steal my trademark. You know, you don't just get to borrow my trademark. If I have a copyright, you don't just get to take my book and put your name on it. If I have a patent, you don't just get to go build the system created by my patent. And so, first of all, let's start with kind of a core question, which is, why should the government grant a monopoly to someone for some technology? And I'll just take, kind of in the chat, pros and cons, right? Advantages, disadvantages. Uh, first of all, should there be intellectual property? Should intellectual ideas be personal property? And then the question becomes, well, what happens if you don't, deal with that? That's kind of so I'll take, any of your comments on the chat, right? But you got to go down that road of asking yourself, um, what if you didn't have any protection? What would it, what's the limit of the function, right? So let me know, what do you think? Hello, Bueller. Okay. Havoc has taken the early lead on the chat, so and appreciate you, typing it in the typing it in. Issues with not having copyright is the inventor could get nothing. Agreed. Sorry, I'm so tired. I'm at a point where this last weekend put me over the edge on sort of like seasonal allergies, and then I realized I needed to start taking some allergy meds. So I'm in the groggy phase of starting up the allergy meds. So I apologize. I'm very yawny today. So yeah, I have a the question is kind of how, right? What does that mean to get nothing? How do you what in particular? Oh, let me see. Havoc said I've had friends who talk about downloads online as prices can be outrageous. But if everyone copies, then as an inventor, I could be highly discouraged. No, that's exactly right. So this is what I mean by the limit of the function, right? If everybody acted like me, how would what would happen with society, right? And we've talked a little bit about this, right? If I just punch anybody that says something I disagree with, then does everybody get to punch me when they don't agree with something I said? You want to live in that kind of a world. I don't think so. So, anyway, I don't. Um, let's see. Jesse said, I think it's important to protect the invention so that people don't use what you came up with. That would discourage inventing and creativity. That's right. Especially if I pour, let's say I poured 5 years of my life into some invention, then I go do it, and then somebody's going, oh, look at that. I'll just go bump it off. Now, they couldn't have figured it out, but they figured it out because they saw me do it, right? And if that's the way it goes, there are a lot of what's really interesting is when you look at countries across the world where there's a high level of technical innovation, like the US. Hang on. Going full Will Smith here. If on myself, yeah. So, Dave, you did misspell evanescence. You're not denying that, are you? Did you change the spelling? Did you edit your thing, Dave? Because I stand corrected. If you didn't, then I stand corrected. All right. No, I'm wrong, man. I'm wrong. Excellent. 3 points for Hufflepuff. Okay, Dave. Fair enough, man. Fair. Totally fair. What was I thinking when I saw it? Nah, I mean, it doesn't say it was edited. So, okay. You're right, Dave. That was a bad call out on my part. So I apologize. Okay, what else? Ah, Steve said, this isn't technology based, but say my brother makes the greatest barbecue sauce, but his barbecue sauce is made up from many other barbecue sauces. Could he brand that as his own barbecue sauce? I don't know. I really don't know. Yeah, man. Yeah, I mean, at some level, right? So Havoc said, everything is a remix. At some level, everything is kind of a remix. That's therein lies some of the difficulty. Well, let me keep kind of going. The idea here is that when you start to think about the problems with intellectual property, patent, copyright, what have you, you got to back up and kind of double check. Well, what happens if you don't have the protection? So I started to say before I got called out for miscalling out Dave. Oh, I was saying that countries that have strong intellectual property protection, and I don't know which countries have the strongest intellectual property protection, But typically I think of the US, I think of Western Europe. Um, Countries with strong intellectual property protection uh, tend to have high innovation when it comes to, I think Japan probably falls into that category. You tend to see, and probably Korea, and I'm guessing, right? I'm speculating. If somebody, in fact, can find like a ranked list of who does, intellectual property protection the best, you're going to see a lot of innovation because it's safe to innovate. You're not just going to do a thing and have somebody grab your executable code and sell it as their own, or grab your barbecue sauce and just tear the labels off, put your own labels on. And you tend where intellectual property protection laws are weak, you tend to see fairly low innovation in that sort of society, country, what have you. So that's interesting, right? Um, Steve, does one determine when someone is in violation of intellectual property? Right. Well, that's what the whole law is about. And I'll show you something. I'll do a live demo here. If there's a patent that exists, but someone enhances that idea to make it better, can they say they developed that patent for themselves? No, they can't say. Well, it depends what you mean by that patent. Do you mean the new one or the old one? And then again, it really depends whether you've added something innovative and things like that. So, but I will say this: I'm just going to grab a couple of books off my shelf right over here. Believe it or not, this is interesting reading. This is my textbook on patent law. It's big. It goes about 1,000 pages. So it's, I'm not going to like reduce it down to, and then we're there. Copyright law. This book is about 650 pages just on copyright. This is trade secret law. And this one goes 550. So you see what I mean? This is just patent, copyright, and trade secrets. We're not even talking this. It's not even like contract law and a bunch of other stuff. There's so much. What else do I have over there? Oh, I've got one more for you that I think you'll get a kick out of. I'll throw these back on my shelf. Which is this one, which is entitled Ethical Problems in the Practice of Law. And this bad boy goes over 1,000 pages. So, I'm just saying there's a reason why you get, 3-year law degree and why what I'm trying to say. So Steve, I'm not, brushing it off. There's a lot of kind of governing principles that go into it. And I'll try to break it down to at least give you just a feel, right? I'm not going to give you, I can't answer all the questions. And as I said, I'm not a lawyer anyway. And most of the time it's going to be a question of it depends, right? Like there are certain things that are patentable, but what about this one thing? What about the other thing? What about the other thing? Well, it depends, okay? Matthew said there could be a lot less motivation to make inventions or patents if you won't make any money off of it, because we will need to do something else to get by financially. And not getting any recognition may not sit well with a lot of people. Although there may be something cool about people collaboratively making code that's free too, like free software, aka open source software and other kinds of stuff. Though it makes sense that the safety of IP is important too. If people could take and or distort your software, that wouldn't be that cool. Right. So the point is, we've talked a little bit about this. There's, in all the issues we've talked about with ethics and society and computing, there's a lot of gray zone. And this is a very significant gray zone. Okay? I got a chapstick up here because my lips hurt real bad. Okay. CR, this may be a little off topic. but it may be relevant. Many Destiny 2 YouTube content creators were hit with false DMCA takedowns. So DMCA is Digital Millennial Copyright Act. Bungie, developer for Destiny 2, has since filed suit, which, among other things, claims that the defendants were infringing on Bungie's trademark. Now, I am right about that typo. By impersonating them, and broke Bungie's copyrights by not allowing the public display of its copyrighted works. There's a link to the suit documentation. Wow, interesting. Yeah, I don't think it's off topic. It's more just like too narrow, and I don't know anything about it, so I can't speak to it without, you know. Yeah, thanks, Kim. Thanks for the shout out. um, yeah, no, that's really interesting, CR. I like that. I like that. And what's the reality? This is why there's attorneys on both sides who each believe, maybe their own perspective. There are experts on both sides who, perhaps each believe their own perspective. So anyway, yeah, bottom line is we're living in a gray zone. You just got to understand that, okay? And a lot of times, you guys being CS types, you want that black and white answer. You want that one or the zero, and you want the thing to fall out cleanly, get me above 5 volts or whatever one is. And it's just not usually that clean, you know? Remember the Triumph of the Nerds movie? And we're talking about, the lawsuit between Microsoft and Apple, right? And you're like, well, Microsoft, you know, sure, they did get it from Apple, but Apple got it from Xerox PARC. But got what? Did Microsoft leverage? And I'm sure, and I've never read that whole case, but I'm sure that Microsoft was leveraging things that Apple did after what they learned from Xerox PARC. You know what I mean? I doubt it was, when you say they got it from them and they got it from them, got what? You know what I mean? That is the struggle. Um, nice. Dave said, I wonder if the relationship with innovation is more closely tied to standard of living or to IP protections. If people aren't just scraping by, are they also more creative? It's a really good question, Dave. It's a very, very good question. And then, of course, teasing apart causation, right, from correlation, that begins to become that's a really, really big, big area. In fact, it's the number one area of confusion, I think, when you try to have an intelligent conversation. Well, I'll give you one example that maybe some of you have heard. I won't get all the way into it, but I had somebody once um, who had basically said, that Utah had a higher than average suicide rate among a particular demographic group. And it was a very narrow, which I'm not going to get into, right? But that Utah had a higher, than the national average, right? Remember logical fallacies? Number one, they had taken there was, in fact, Utah had a higher than average suicide rate for a fairly broad swath of sort of age demographics, and in particular, sort of teenage and young adult, of which this other one was a part, but wasn't uniquely different, right? In other words, there's this swath of demographics within Utah, of which they cherry picked one thing and said Utah has a higher rate in that one thing, but that thing being part of a bigger thing. Does that make sense? And used, kind of misused that. In other words, causation, and they were making a point about causation, that this all happens because there's something about Utah religion or whatever that makes it all harder, makes it all more difficult. And I was intrigued, so I went and did some research and discovered that the entire Intermountain West and Pacific Northwest actually tracked together, so that Utah had comparable suicide rates in those demographic areas to, say, Oregon and Washington, which were far less religious and far more politically liberal. In other words, a lot of just bad correlation analysis Then when you jump from bad correlation analysis to causality, and then say, here's why. Well, if you're going to start talking about, this is why one of the reasons it took so long to do studies about tobacco. And for starters, the tobacco industry was working pretty hard and spending a lot of money. But independent of that, you can't run a controlled experiment where you assign one group to smoke for 50 years and the other group to not. And then you can't control with a controlled experiment. So you're basically trying to compile enough correlation to draw some sort of causal conclusion. It's a hard thing to do. Okay, anyway, so where did I get from all that? Correlation and causation. Well, back to Dave's comment, whether it's more closely tied to standard of living or to IP protections. And those two probably go hand in hand, I would imagine. But yeah, these are very difficult dynamics to tease apart. Absolutely. Okay, let me keep going. But just understand that it's a gray zone. That's all. That's the main thing I wanted you to understand. The idea behind intellectual property is to provide a limited monopoly to the inventor. Trying to reward creativity, trying to reward innovation, right? You're trying to protect the rights of the creator. If if I'm Picasso and I painted a painting and somebody just took a picture of it and began to sell prints of it, that violates my intellectual property rights, my copyrights to that. If somebody takes my story that I wrote and just takes the text and changes a few words, sticks their name on it, they violated my copyright. I have a right to exclude. A limited monopoly is a right to exclude other people from doing certain things. And the goal is to foster future creativity. That's really what we're trying to do as well. So let's talk about each of these, and we'll just see how far we get today, and then we'll wrap up the rest of it. Maybe wrap up on Thursday. And I hope you find this interesting. 5 of you said you would potentially be interested in going to law school. So maybe especially interesting for you. For the rest of you, you're going to go off and be software developers, most of you. Are you ever going to apply for a patent? Are you ever going to be accused of patent infringement? Those are both things that might happen. I have 2 patents across my career. Could have been more if I sort of knew it was a thing, and I certainly invented more than 2 things that were worthy of a patent. Are you violating somebody else's trademark or trade secrets or copyrights? The other things, employment agreements, intellectual property rights, non-compete, non-disclosure, that stuff you're going to deal with all the time. So it's a little boring, but I hope that this is, interesting enough as a topic. But we're going to kind of take it in turn, okay? Reading Dave's comment, my intuition suggests that standard of living is an important factor. I expect an impoverished nation with strict intellectual property laws would still rank fairly low on some kind of innovation scale. I think it's just that most of the population is focused on the next meal and not quantum physics. Yeah, I agree. I agree with that, Dave. I that jives with my intuition as well. Yeah. And it's an interesting question. I know there's been research, into that. Okay. Patents. Oh, and let me see. No, I don't need to say anything about that. Patents are a set of exclusive rights, a limited monopoly for a limited time period. The monopoly associated with a patent is the right to exclude others from practicing the claims. You might be practicing them yourself. You might have products yourself. You might have a company. You might do it, or you might not. And it doesn't matter whether you're doing it in order to, the patent is the right to exclude others. That's what it grants you. But if they really want to do it, then they can license it from you, for example. The thing that's been invented has to be new, inventive, useful, or industrially applicable. Again, I'm not a lawyer, but these are just kind of some guiding ideas. And it needs to be non-obvious to one of ordinary skill in the art. So this is this is language that we use. One of ordinary skill in the art might be somebody with a bachelor's degree and a couple years experience, or focused experience in certain areas like data communications or something, and some job experience, some educational qualifications. And the idea of one of ordinary skill in the art is basically that the patent has to be capable of teaching one of ordinary skill in the art how to practice the invention. Okay? The patent doesn't have to start by saying, here's an if statement. Let's teach you how to, it doesn't have to teach you computer science. But if you had a degree in computer science, it would teach you now what to do if it were like a software patent. Or if it was like, anti-gravity boots was the patent, then one of skill in the art, I'm making crap up, right? One of ordinary skill in the art might be somebody who has, I don't know, undergrad degree in physics and plus some, mechanical engineering experience or something that would equip them. Then you can say, okay, I can start talking to you at an educated level. That's the idea. So that's the notion that when you take somebody, everything's non-obvious to somebody that doesn't know anything at all about the field, but it needs to be non-obvious to somebody who has skill in the art. And then at the time of the invention, it's always focused on that time. It's easy, to look back and say, here's a patent from 20 years ago. Well, that's really obvious. Well, it really is from right now, from sitting here looking back, But at the time, you got to put yourself back at the time. Okay? Um, Radioactive was responding to Dave saying, I agree, but I think the inventor still needs some reason to invent. If someone's life is perfect and they see no need to try and improve life for themselves, or they won't be pushed to innovate new things. Yeah, I think there is a little bit of a catch-22 in all of that. I do think that if every time I do anything innovative, there's no law to protect me, I can't create the benevolent cycle. Okay. There's a process that we call prosecution of a patent, which is this process of applying for the patent and following through. And that's when you see patent pending or pat period pending. It means we're in the process and we want you to know that the patents, we hope the patent is coming. It does mean it's not granted yet. The format of the patent is basically two parts: written description and the claims. The claims are the specific things that are claimed, and that is the invention. By definition, the claims are the invention. They are what is claimed. Okay? The written description is going to teach me, as one of ordinary skill, how to do the thing. And it's going to give me certain kind of embodiments, ways of doing it. Like, here's one approach. You could get a database and you could write code to do this, that. And the preferred embodiments give you an illustration of how to do it. And there's some, kind of implications about whether that limits or doesn't limit, the scope of the claims. There are situations in which the written description does create some limitation by being specific about certain things, or by failing to provide any, other kind of embodiment other than a specific idea. I don't know if that makes any sense. The claims come in the form of independent and dependent claims. What else really to say about that? That's probably a little bit detailed. Yeah, I don't need to say much more about that. So Did I go the wrong way? I did. All right. So infringement of a patent is when we use the invention without permission from the patent holder. And in order to use the invention, we have to practice all the limitations of one claim. I'll show you some examples, okay? And then there's direct infringement where I manufacture, import, sell, or offer for sale technology to practice the patent. And there's indirect infringement where I sort of induce somebody else to do it or I contribute. If you take this thing I built and you plug it onto this other thing, then it will become infringing, that idea. A few subtleties. Well, let me throw a couple on you. Let me show you my most infamous patent. Okay, I'm going to try to blow this up so you can see it. Let me see how that's lining up. Yeah, you can see it. Check it out. What do you think? Let me know what you think of this. It was filed in 2002. It's called linked list. Holy crap. Now you're probably thinking to yourself, well, surely it's not like that linked list. Ha! Oh, but you'd be wrong. Let's read it. Let's look at it. Well, there's a picture. The abstract. A computerized list is provided with auxiliary pointers for traversing the list in different sequences. One or more auxiliary pointers enables a fast, sequential traversal of the list with a minimum of computational time. Such lists may be used in any application where lists may be reordered for various purposes. Check this out. This is crazy. There's diagrams. That's it, 2 diagrams. By the way, this thing is only 5 pages long, which also is an indicator. Look at that. A little more than a page to teach me how to do it. And right here, starting with 1, in order for me to infringe this, now you guys had data structures, right? Didn't you build linked lists? A computerized list that may be traversed in at least 2 sequences comprising plurality, which just means more than one, of items that are contained in the computerized list. So there's stuff in the list. A primary pointer and an auxiliary pointer for each of the items, blah, blah, blah. You walk through this thing and you're like, holy shiz. Somebody patented the linked list in '02. Now, I don't know what the current state of this thing is. You know, there's not going to do anything for you. But this is just an example of a complete meltdown of the system. And also, what are you thinking? First of all, the inventor, Ming-Jen Wang. Also, LSI Logic is a real company. It's not like somebody just being weird. My guess is that a lot of companies have, like on-site attorneys or like here, attorney agent or firm who are constantly looking for things that they can patent, and they're just going through the code, going through stuff. And these are people that knew enough to apply for the patent, didn't know enough to know that linked list is something we teach people in like second or third semester of a CS undergrad. Isn't that crazy? It's insane. Really, and I'd love to read the prosecution history. Like, what did they bring up? Like, what was the big innovation that allowed them to get this thing passed? Okay, let me give you another one. This one is, I don't know, it's less egregious, honestly, even though it's insane. Scout it. Method of exercising a cat. Method for inducing cats to exercise consists of directing a beam of invisible light. First of all, I don't even think that is, that's contradiction in terms. A beam of invisible light. If it were invisible, you wouldn't be able to see it. Produced by a handheld laser apparatus onto the floor or wall or other opaque surface in the vicinity of the cat. Then moving the laser so as to cause the bright pattern of light. It's bright, but it's invisible. To move in an irregular way, fascinating the cats and any other animal with a chase instinct. You ready for this? There you go. There's the figure right there. Okay. This, by the way, as any of you who have ever had both a dog or a cat and a laser pointer know that this is obvious. This was not innovative. They didn't. What was the year on this thing? Oh, and by the way, look at the laser pointer. Holy crap, that's quite the laser pointer. What's the year on this thing? 1993. You know, that's it. And the entire patent, again, is like less than a page for this summary of the invention discussion. You have to teach someone of what is someone of ordinary skill here? A cat owner? What's the ordinary skill? To practice the invention. It's insane. Yes, Matthew. So yes. Now again, I don't know if this patent is still valid, if it's been, if somebody's ever gone after it or whatever. But yes, if you ever used a laser pointer to play with a cat after 1993, you would be in fact infringing this patent by using the claims without permission. Yeah. And when you got into what's the class we do after what's the class where you learn linked lists? I'm blanking on the numbers. What is it? 2420? Yeah. So when you wrote your linked list in 2420, assuming that other patent has still not been invalidated, you were in fact violating and infringing on that patent. Crazy. Also, look at the claim right here. Inducing aerobic exercise in an unrestrained cat. So if it didn't induce aerobic exercise, you wouldn't infringe. If the cat were restrained, you wouldn't infringe. It has to be an unrestrained cat. Directing an intense, coherent beam of invisible light. I would argue that this claim language is there's a term that they use. What's the term? Basically, it's a claim that doesn't make sense. It's internally inconsistent. I can't come up with the claim right now. I'm too tired. But invisible light, I think, the light has to be invisible for you to infringe. But if the light's visible, then you wouldn't infringe, conceptually. Let's see, produced by a handheld laser apparatus to produce a bright, highly focused pattern of light at the intersection of the beam and an opaque surface. Said pattern being of visual interest to a cat. So if your cat didn't show interest, you wouldn't infringe. It's the worst patent I've ever seen. Selectively redirecting said beam out of the cat's immediate reach to induce said cat to run and chase said beam and pattern of light around an exercise area. That's it. If there's anything in here you don't do, then you don't infringe. You have to do everything it says here. It's really absurd. It's crazy. You gotta, and then there's some sort of theory behind why that even is a thing. You know what I mean? Um, hang on. Okay. But isn't that insane? Isn't that insane? There's another one that I don't have it right here in the same folder, but it's a patent on swinging a swing like side to side, like I did in the '60s, or any child who ever had a swing, who would did this thing so you could kind of get the swing going side by side. You know. Dave claims the patent for being self-aware. Right. Unlike both the patent um, applicant and the examiner. But let me give you my actual favorite, my truly favorite patent. And I mean this, I'm not being facetious. I mean this like literally and seriously. US patent, musical instrument support. The patent holder is Edward L. Van Halen of Los Angeles, filed in 1985. It's a supporting device for string musical instruments like guitars, constructed and arranged for supporting the instrument on the player to permit freedom of the player's hands to play it in a new way. In other words, to free up both hands. So, for example, you can do tapping like Eddie Van Halen was famous for, innovating. And then you got to love that right there, man. That, my friends, is what I call a patent figure. It shows up right here. Look at that. But I love this. Okay, isn't that great? That is, of course, modeled after Eddie Van Halen. Figure one, figure two. You got to, but this is actually innovative. This actually Eddie Van Halen was doing. Notice it's just a little longer. About how to do this thing. You get out here to column 5, and then column 6 starts the claims, right? No, but I really, um, but I dig this because So first of all, Eddie Van Halen was freaking brilliant, for starters, and he also, if you do a, let me see if I can pull something up. Google Patents. Okay, let me bring this over here just to do this thing live. Edward Van Halen, inventor. I just want you to see how many results there are. 5 patents, man. Humbucking pickup and method of providing permanent magnet extending through something. Eddie Van Halen actually did do experimentation with things like pickups on electric guitars. In particular, this thing he did with the humbucker, um, adjustable string tension control. I think that's kind of like a whammy bar, a humbucking pickup. Um, Music. There's the instrument support, guitar peg head. I mean, he was constantly innovating, creating and what have you. So, okay, here, let's check this one out. Not mine. I wonder why I'm on that one then. Why does that show up? Golf club head. I wish that'd be great. Um, I'm just curious. Oh, it's because I got to go. Yeah, these are my 2 patents right here. This one, wireless data transfer. two of my grad students, but it should be, yeah, it's assigned to TomTom International, and then the other one is assigned to Kinpoint, which was a company I founded. Yeah, so Eddie Van Halen has three more patents than I do, but I still got opportunity if I want to get after it, right? Anyway, but this is a legitimate invention that he had to come up with, so he could perform and then flip that thing out and then get and do the finger picking while still supporting your guitar. He's solving an actual problem created by the context of his innovative style of play, right? So I hope that's interesting. Where are we? Yeah, so I agree with Matthew. That does need to be a meme. All right, we talked about that guy. The few subtleties. The patent holder doesn't have to be the inventor. For example, that one I showed you, I'm one of the inventors on the wireless one. I was the last inventor by way of contribution. Usually you order them by contribution. Don't have to, but I always did. And the one assigned to Kinpoint, I was the main inventor. It was really my innovation, more than the others. And in the other one, the wireless one, Eric Hall goes first. He was very much the main innovator, and then Dave and I contributed in other ways. But everyone has to contribute for a patent to be valid. That are named inventors, right? Um, but in both cases, the patent is actually not owned by the inventor. In both cases, the patent is owned by a company. Okay, and that's fine. That's fine because inventing is one thing and manufacturing is another thing, right? If you said only the inventor can practice the patent, that would really be unfair, right? The inventor might be really smart, person who doesn't have the means to do production or even the aptitude to do production, you know. Now, there's also this notion of companies that have portfolios of patents and their focus is on litigation. They are one example of what is sometimes referred to as a non-practicing entity. That just means that they're not building product; they own the patent. Um, Sometimes the term patent troll is sort of tossed around. And I have my own opinions about the sort of what constitutes a troll, as opposed to non-practicing entities. Most universities are non-practicing entities in the sense that they have patent portfolios that come from their professors, much like BYU did on those two patents that I did. So they're non-practicing entities, but they're not out, kind of suing the world, and there's some other things that in my mind, in other words, just because you're suing the world doesn't make you a patent troll. There are some behaviors, and it's very subjective. But in any case, um, I do feel like we've sort of evolved to a point where patents are meant to be innovative. They're meant to be, a quantum leap. You come down to, when you find yourself down to some little definitional word and the whole part of infringement pivots on whether it's this or this. To me, that's not a lot of differentiation from what the state of the art was before that invention, and yet it's supposed to be non-obvious. So it's not an obvious next step. Does that make sense? I hope this is interesting. Um, Let me do a survey real quick because you guys are extra silent, not silent, but you're a little quieter than normal, and I'm tireder than normal with my stupid allergy medication. But I'm dropping a survey, and you know how it works. You're not going to offend me. Um, the question is this discussion of intellectual property is interesting so far. And it's okay if it's just like boring as hell to you, okay? If it's like really like losing you, it's okay. This doesn't have to be interesting to everybody. And I'm not going to look up who's voting yes or no, by the way, okay? So for the no's, you're free to like. I find it interesting, but it's a little bit pedantic. You know what I mean? While the survey's going on, and by the way, hopefully next time. Um, okay, Dave, that's pretty good. That's pretty good. Oh, okay, yeah, Jay. So, thank you. Yeah, it could be more boring. Could be boringer. Um, I think next time will be a little more interesting because we'll be talking about stuff that applies to you, like contracts and what do you do when you join a company and things like that. But it's not a good combo to be talking about this stuff while I'm on allergy meds and feeling kind of low energy. But this last thing is patents suits as a war of attrition where you just keep pounding, pounding, pounding. Who's got the most money? Winds up being potentially at an advantage. Not always, but just saying. There's it tends to go into some funny spaces, right? Okay, that's it for patents. Let's talk for what do we got here? 8 more minutes. Let's talk about copyrights. Um, by the way, can I just say this to Jay? Um, in the past, when I did this at BYU, on a few occasions, I had actual attorneys come. I think there were like 3 different times that I had actual intellectual property attorneys, you know, like big cheeses. And holy crap, that was boringer. Okay. I'm telling you, it was way more boring. I was interested in the space and I was still like, oh, that's brutal, man. That is brutal. All right, copyright, same idea. Exclusive rights to the author or the creator, the right to copy it, distribute it, adapt it for some period of time, and then it goes into the public domain. Once it's in the public domain, you don't have to pay royalties to anybody to use the stuff. And then there are over the years, the definitions of timing have changed. And if you think about it, it's a little dicey. Like it used to be like so many years after the death of the author, right? But then all of a sudden you get into issues like what do you do with, say, Mickey Mouse? Is it reasonable for that to be, a perpetually copyrighted thing? Because what do you do when it's a company that owns the copyright? Because until the company dies, what if it's Disney? It doesn't seem fair to say to Disney, well, it's been, Walt Disney died and it's been X number of years. Now Mickey Mouse has right, exactly where Brandon's going where Mickey Mouse is now in the public domain. That'd be tough. That kind of wouldn't really be fair, I don't think. No, but it's not about money talks. It's about is that fair? This is a corporate trademark. This is a you know, corporate asset. If you owned trucks, right? You got to remember intellectual property and then other kinds of property. Would you say that you bought some heavy equipment in a company and then, right, Max saying it's almost like their image. You take that away, it goes in the public domain. There's nothing Jane Austen still sort of floating around. So if I wanted to take the text of a Jane Austen book and publish it, I'm free to do it. I can make my own publishing company. People do it. Set up to produce the classics. Well, why is it that you have so many various brands of the classic when you go to a bookstore? Because there's no royalties. You're not having to pay the author. Everything you sell is yours, and you don't have to produce it either. It's already there, you know? So, and there was another one. What was it called? It was called the Gutenberg Project. Started back in the 90s, attempting to put online just, every public domain book so you could read all the classics, right? But yeah, there's a difference when you deal with corporate versus personal, you know? corporate copyright versus personal copyright. Um, Almost anything can be copyrighted, and you're automatically copyrighted without registering. But if you do register, that's the difference between the little C with the circle around it versus the little R. That's a little sign language R with the circle around it, right? There, you can just claim copyright by the fact that you just said, "Yeah, that's me. I wrote that," and then it's copyrighted. But there's different rights you have when you register the copyright. There's also this idea of fair use, okay? And fair use is this idea that, for example, if we meet in a classroom and I am going to play for you, let's say we were watching the Cringely videos or the Social Dilemma on Netflix, and we got, last semester we watched the Social Dilemma in class. So I just logged into my Netflix. So public confession time. I logged into my Netflix account and I played it on a screen in a classroom. I didn't stream it to YouTube. I didn't stream it anywhere else, right? And everybody who was sitting in the room was in the class, registered, paying tuition. There's a number of constraints. It was for educational purposes. It wasn't a public broadcast. But if you take and do like movies in the park, at your apartment complex, and you charge everybody $5 and you just take a DVD, pop it in a player, put it on the big screen, you're probably violating copyright law when you do that, you know. And almost certainly the licensing agreement on the CD, but maybe copyright law. Okay, what do we got here from Dave? All right, what are we doing here? Oh, these are maintain do. Sport, not Sprite. Oh, these are all knockoffs. Strite, cold cola. Nice. Okay, Dave wins the chat. I just want, and also Dave started with 2 points for Hufflepuff um, for for correctly calling me out on calling him out on misspelling something that wasn't misspelled. So you already started with a slight advantage, but this one's a winner. Unique do. I like maintain do myself. Fantu, funny, chat cola, cold cola, strite. Yeah, my favorite. We should make a vote on this, but my favorite is maintain do. Because right, once you borrow the colors, and that's now we're into trademark, by the way, Dave. -1 from Hufflepuff. Um, that's trademark, but we're going to get there. So fair use, you can use it for like commentary, criticism. I can parody it. Um, I can use a clip on the news. I can podcast and grab a soundbite from anything. Okay. Now there's a separate issue, which is how aggressively YouTube polices this. But I think, thanks, Brandon. Um, where was I going? Oh, my own opinion is that YouTube is absurdly aggressive when it comes to enforcement of copyright. They're not really enforcing copyright. They're enforcing certain customers' desires, and they're a private platform, so they can take down something, you know. But I think that YouTube, in my view, clearly takes down stuff that is absolutely in the domain of fair use. But of course, any platform can identify whatever their standards are, but just don't say it's taken down for copyright infringement when it's not. It's being taken down because it violates your terms, which include you can't even copy certain things for fair use. That's all that really means. Let me see. I got 1, 2. Let me do this last one. There's been the kind of guiding laws, Digital Millennium Copyright Acts, the DMCA. But this has evolved so much, and I haven't read that entire. Those books, I've read chunks of those books, all of them, but I've not ever read all of one of them. So I don't even know what the current state is, honestly. It's gone round and round. But the DMCA, I believe, is still the fundamental governing law. Okay, when we come back, we're going to hit trademark. which will relate more to Dave's thing, but I still win him the chat on this thing. So let's pause now. It's quarter after. That's clock. I'm just going to stop abruptly because I'm so tired. Yeah, I'm just looking at the comments. Brandon's, yeah, you're welcome, Brandon. Um, yeah, that's right. Yeah, that's really just about YouTube, right? That it's easier than dealing with legal issues and whatever. Also, we'll get into it. Let's talk about it. Let's start with YouTube next time. I got some stuff in there on our readings from Rick Beato and some others about that. We'll get back to it. All right, man. Hey, stay safe. Be good. Take care of yourself. Be gentle with yourself. Uh, Remember, you're awesome. I love you. Do all the good things. Good luck down the stretch.